Hi everybody, my name is Derek Christensen. I'm the owner of Legion Law, an estate planning and probate firm in Dallas, Texas. Today I wanted to talk about who can start a probate. But before I dive into that, I want to let you know how to reach out to me. You can find me in my email, Derek, D-E-R-E-K, at legionlawpllc.com, or you can find me in my website, www.legionlawpllc.com. So with that, let's dive right in. So this is an interesting topic because oftentimes people think that they can just bring a probate if somebody else won't. And in reality, it's not the case. I've had many instances where children will reach out and try to do probate for their mother because the mom doesn't want to take care of all this stuff. And at the end of the day, they actually can't in many circumstances. It really just depends on the circumstance. So I'll get into the details. Texas specifically states a list of people who can bring or who can start a probate. More specifically, these people are beneficiaries under the will or the default laws of Texas. These are going to be personal representatives of the estate who are listed in the will or who are allowed to be personal representatives under Texas law. And these are going to be creditors. The state of Texas can actually be involved as well. Many other parties, but those are kind of the main four right there. Now, if you're not one of those four people, you really can't be the one who starts the probate. And ideally, Texas actually states we want this order as well. So like all of these people can bring lawsuits, but this is the order by which we'll listen to those lawsuits. We want this to be prioritized. And the first one is definitely going to be the personal representative of the estate. So this will be the executor listed in a will. This will be a trustee listed in a trust. This will be if the trust is trying to resolve a question before the court. And this will be people who are entitled to be personal representatives under the default laws of Texas, if that applies. So we're looking for the personal representative. To answer your question, more often almost all the time, it is always the personal representative who starts probate. Now, that doesn't change the fact that probate is a peculiar type of lawsuit where, well, it's not even a lawsuit. It's really just a legal matter you're bringing before the court. It's not a lawsuit until somebody is suing each other, like two people are fighting. But if you have one personal representative and that's it, they can bring their matter before the court, and then the other people I mentioned still, beneficiaries, creditors, the government, they can participate in the matter as well. They will join in as a party and they'll bring their own concerns or their own matters before the court to resolve the entire estate entirely. So, in other words, if you're a beneficiary, you can still participate and you can still come in and say, hey, whoa, hold up. We actually want this to happen. This is our new application that we think should happen. So you technically can start it, but oftentimes what's going to happen is the personal representative will start the probate and then anybody can participate if they want, and then we resolve everything and we're good. If the personal representative is lazy, they don't do it, they don't want to, you don't know how to get the ball moving, the beneficiary is more than welcome to do so, but if the personal representative gets on their feet and starts participating, then the court is going to say, hey, we have that list, that prioritized list. We want the personal representative, so we're going to go with them instead of you. So it's a little complicated is the answer to the original question, who can start a probate? But ideally, the personal representative, and if not, beneficiaries. Now, when I say beneficiaries, I also need to include the fact that this is a current beneficiary. This is not a contingent beneficiary. I've talked about it in previous videos, but if you're a contingent beneficiary, you're excluded entirely because a contingent beneficiary is someone who's entitled to assets from the estate only if a certain condition applies. And if that condition has not applied by the time the person passes away, then you are contingent, you did not receive anything, and you are not a beneficiary. You're just listed as one who could have been, but you never were. So what do I mean by that? I mean I will give 50% to child A, and then 25 to child B, and 25 to child C, but only if child C stops drinking alcohol for 2 years. And if I'm drunk at the time that person passes away, and I'm child C, I don't receive anything, and so therefore my 25% doesn't go to me. I don't get anything. And because I'm not receiving anything, I'm not a beneficiary, I'm not allowed to bring a lawsuit, let alone participate in the lawsuit. Doesn't mean I can't try, but I'll get kicked out very quickly from a court. So that's really, really important because, again, oftentimes these children, they'll come to me and say, hey, I want to take care of my or I want to take care of my dad's estate, but my mom is the personal representative on the will, but she doesn't want to do anything and she's, overwhelmed, so let me take care of it. And I'll say, oh, well, are you a beneficiary? And they'll say no, because it's supposed to, everything go to mom, and if not mom, then kids in equal shares. And so the kids are contingent beneficiaries because the contingency is if mom passes away. But mom hasn't passed away, so the kids aren't entitled to anything, so they're not beneficiaries, so they can't do anything. So either way, that's a long way to say personal representatives, most ideal, and that's why you want to pick a really good one, because if they don't do anything, then you start having kids do it, or other beneficiaries do it, creditors will do it, and then if someone who's higher on the ranking comes in, then it makes everything messy. So either way, ideally the personal representative, if not, get a beneficiary to do it. So, and you have to be a current beneficiary, not a contingent one. So with that, if you have any questions on how to start a probate, which one of the 7 or 8 different paths of probate in Texas to go down, what is it going to look like, what does it cost, how much time does it take, all that stuff, feel free to reach out. Be more than happy to answer your questions and be a resource. You can email me directly, Derek, D-E-R-E-K, at legionlawpllc.com, or you can find me on my website, www.legionlawpllc.com, where you can go to our Contact Us page and schedule a free over-the-phone consultation directly onto my calendar. So thank you so much and have a great day.